Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida. And I'd like to talk briefly today about non-compete agreements, trade secrets, and preliminary injunctions. If you are involved in litigating a non-compete or trade secret case, one of the most important stages of the case is the preliminary injunction stage. So what often happens is this. A complaint is filed alleging a violation, non-compete, theft of trade secrets. In some instances, the plaintiffs will seek a temporary restraining order, or TRO. This can be issued at the beginning of a case, ex parte, or on very limited notice, and will last until usually the preliminary injunction is heard. So if things go accordingly, there should be a full-blown evidentiary hearing on a preliminary injunction. And I actually just won an appeal in the 11th Circuit Court of Appeals on this very point, confirming that under 11th Circuit law, if there is a legitimate conflict between the parties' version of events, then the defendant is entitled to a preliminary injunction hearing, to a full-blown evidentiary hearing. So at that point, you have the evidentiary hearing. And the reason why that hearing is so important, the reason why that stage is so important, is because of what can happen as a result of such an injunction. If you're a defendant and you're accused of breaching a non-compete agreement, stealing trade secrets, etc., you can be enjoined. You can be prevented from doing business entirely. You can be barred from conducting business in certain markets. You can be barred from working with certain customers. You can be barred from selling certain products. That obviously can lead to a tremendous amount of lost revenue and economic damage. So that's why the preliminary injunction stage is really so important. And that's another reason why so many non-compete and trade secret cases will often settle based on what happens after the preliminary injunction hearing. If the court enjoins the party, if the court doesn't issue an injunction, either way, the case often settles because one side feels that they have the upper hand in the litigation. So with that in mind, I'm going to make two very specific points about defending these sorts of cases. Number one, there are important distinctions in the applicable law based on whether you are litigating the case in federal court and whether you're litigating the case in state court. And I know that sounds a little bit squirrely, but I will give it to you point blank. If you are in federal court and you are seeking an injunction, you have to satisfy the applicable federal rule. In this instance, that's Rule 65. Basically, to get an injunction, you have to demonstrate that you have a substantial likelihood of success on the merits, that the balance of harms tilts in your favor, and that it would not disserve the public interest. When you look at the balance of harms, there's an issue there with respect to irreparable harm. Basically, the most important factor with respect to injunctive relief is always a showing of irreparable harm. You have to establish that if an injunction does not issue, you will suffer irreparable harm. Your business will be damaged in some devastating manner. You'll lose goodwill, etc., etc. In federal court, you have to actually prove that. You must put forward evidence to that effect. In state court, you don't have to do that. That's why, if you're defending these cases, it's so critically important to be in federal court. In federal court, the plaintiff is going to have to proffer that evidence. They're going to have to establish, more likely than not, that they are going to suffer irreparable harm. It has to be a compelling showing of such harm. In state court, Florida state law actually presumes irreparable harm flowing from the breach of an enforceable non-compete agreement. So if you're in Florida state court, the other side, the plaintiff in the case, does not have to prove that their goodwill is being damaged, that you're stealing their customers, that their company is losing revenues, etc. That is simply going to be presumed. That's a tremendous distinction between litigating the case in federal court and litigating the case in state court. So what does this mean? Well, number one, it means if you get sued for breach of a non-compete agreement for theft of trade secrets, and you're being sued in state court, if you have any ability to remove, then you want to immediately remove it to federal court. If you haven't been sued yet, and if there's some angry letters going back and forth, and you have a predicate for federal jurisdiction, most likely just be diversity, then maybe you want to consider filing a declaratory judgment action in federal court. I've even been in, squirrelier situations where there was a forum selection clause that potentially could have relegated us only to state court, but I sued them first in federal court, and they went along with it, and thereby I was able to avoid litigating the case in state court and avoid Florida procedural law with respect to a presumption of irreparable harm. So the upshot there from all of this is that, number one, preliminary injunction is extremely important, and it may be the most important piece of non-compete and trade secret litigation. It's often dispositive. That's number one. Number two, if you are defending a non-compete or trade secrets case and you have the ability to get into federal court rather than litigating the case in state court, at least in Florida, I strongly urge you to do so, to remove the case, to get it in front of the federal courts, because you will have immediately, you're putting aside everything else in terms of, the bench being so deep and, being kind of more of an orderly process, you will already have, right from the outset, certain tangible benefits with respect to the applicable procedural law. Jonathan Pollard, non-compete and trade secrets attorney in downtown Fort Lauderdale, Florida. If you have a question or concern about a non-compete or a trade secret dispute, please feel free to give me a call. I'd be happy to talk with you about it. Thanks a lot. Have a good day.